Hi. All right, today we're going to talk about indemnification. First, what is indemnification? It is when a person agrees to financially compensate another person for claims brought by a third party. What's a third party? A third party is a person other than the two people agreeing. So you have party A and you agree with party B, and person C brings a claim against party B. For example, I'm a landlord. I lease you some space, and I say, I want you to indemnify me against any claims brought by anybody coming into the store who injures themselves. Don't know who they are, and they're not part of our agreement or anything, but if they come into the store and they sue me as the landlord for their injuries in coming to the store, you as the storekeeper will pay for the lawyer's fees and any damages or injuries that person sustains. That's indemnification. Are all indemnifications the same? No. There are contractual terms. They're negotiated terms. They're all different depending on the contract. It's the breadth, the scope. Some are capped, some aren't capped. It depends what the parties agree to in the contract. That also means they're not boilerplate. So please, if you see indemnification provisions in a contract, look at them very carefully. They are a negotiated term. You're not required to agree to them, and they're not all the same. And they can be quite broad. The landlord might say, I want you to indemnify me for any injury to my building that is caused any part by anything you do, whether you're 1% at fault or 100% at fault. So let's say the building burns down and you didn't call the fire department quick enough, but you didn't cause the fire or anything else, but you were like 1% at fault for not calling the fire department quick enough. Under that indemnification provision, you'd be 100% responsible for the loss of the building when your responsibility was very tiny. So they can be very dangerous, and they have to be looked at very carefully. Does indemnification relieve the person being indemnified from any claims by third parties? No. This is a huge misconception. People think that they get an indemnification, that they are somehow shielded, have a force field all of a sudden comes around them, and third parties can't sue them. They can only sue the person indemnifying. Not true. That they can be sued irrespective of the existence of indemnification or not. All the indemnification does is allow the person who's indemnified and being sued to turn to the person who indemnified them and say, you're responsible for this, for the payment of the fees and the cost of this lawsuit and any damages, and you're to pay those monies to the person claiming, or if I have to pay any monies, you pay me those monies. That's all it is. But it doesn't stop the lawsuit against you. It just drags in the person that indemnifies you. That raises the question, well, what happens if the person indemnifying you says, no, I'm not going to do it? Then you're going to have to sue them and bring them into the lawsuit and force them to indemnify. It's a contractual agreement. And like all contracts, they're only good if you're willing to enforce them. Worse, what happens if the person indemnifying you turns out to have no money? Then that indemnification is worthless, useless, because they're not going to pay you any money to offset the claims against you that were brought on by a third party because something done by the person who was indemnifying you. I mentioned earlier capping indemnifications. It's an interesting trend in the law where you enter these contracts, you say, okay, I will indemnify you, but only up to $5,000, $15,000 or $25,000 or whatever amount. And any claims above that, including attorney's fees, I will not pay for. Or you can say over time, there's a time limit on the indemnification. I sell you my business and I will indemnify you any claims arising under that business. But only if those claims are brought within 2 years of the sale. Any claims brought after that, I won't indemnify you. So you can have that kind of time restriction, or you can have a monetary cap. Those are great modifications to put in indemnification clauses. Do you have to use the word indemnification in the contract for it to be indemnification? No. Titles in a contract are fundamentally not important. It's the context. As long as the relationship you describe in the contract is one of indemnification, then it's indemnification. For example, you represent to me there's no problems with your product, there will be no problems with your product, and if there's any problems with your product that I am buying and reselling, you will pay any claims that come about as a result of your product. Okay, that sounds like a representation, which it is, but it's also indemnification, fundamentally indemnification, but never use the word indemnification. So you can accomplish indemnification by calling it indemnification or describing it without using the language indemnification. People often use the latter, i.e. describing indemnification without using the word, because when people see the word indemnification in the contract, they tend to get overly concerned. They want cross indemnifications, or they won't agree to the contract. So if you just describe it, not without using the word indemnification, sometimes people are more agreeable to it. Hope that was helpful.